Thank you very much, Helen, and good morning to you all. And I was mentioning to somebody yesterday. We were talking at the reception at Reverend Paul's house, and I mentioned to somebody that was not on the program, but Dr. Bill Peterson twisted my arm. And so he assured me he'd twist everybody's arm. I don't know if that was a good thing or a bad thing, but anyway, I stand before you today to talk about the National Labor Relations Act, otherwise known as the Wagner Act. So Helen mentioned that she's from the social sciences. I am even more removed from the fields that you represent. I'm in the much hated business school. And so, as with the brunt of business professors, we can carry on at length without really knowing what we're talking about. And I stand before you as a prime example of that. Well, if you think about the modern worker and workplace, we take a lot of things for granted. So, for example, if we feel like quitting, we just say, I quit, and we dramatically rush out the door. That we see television shows that say, hey, you're fired, and then the worker is dismissed. Yet, there are a lot of protections today that were not there that many years ago. So just to give you a sample, we have the minimum wage laws, so you can't really pay people whatever you feel like paying them. You have the Occupational Safety and Health Act, the OSHA, so you have to maintain certain working conditions in the workplace. You have the Affordable Care Act now, and there were various forms of health insurance before that, and many large employers routinely provided health insurance even before the Affordable Care Act. If you were to be laid off, you had the benefit of unemployment insurance. You had some kind of income security. If your money was in a pension, your income was protected by the ERISA. If you complained against your employer, you have whistleblower protection legislation. You have Family and Medical Leave Act, if you have to take care of family, so on and so forth. You have the Civil Rights Act. In short, the worker of today is much better protected than the case was, say, even 50, 60 years ago. And the act that I'm going to talk to you about, the legislation I'm going to talk to you about, is a landmark legislation in the sense that it really changed the way society thought about workers, the protections that were afforded to the workers. So, in other words, it was a very important part of a societal transformation, and I think it's apt that this paper is included. There's no paper actually, it's a paper. But that this presentation is included in the topic of transition. So this was really a transition from older ways of thinking about workplace relationships to a more progressive or modern approach. So really it's a kind of a watershed moment, I would say. Okay. So what am I going to talk about? Just in summary. So, what I'm going to tell you is that prior to the passage of the Act, workers were often at the mercy of employers who resisted their attempts at collective representation. If you think about it, if you ask anybody, even today, if you ask a boss, who is a good worker? And the answer would probably be somebody who comes in on time, does what he or she is told, contributes ideas, and if you want somebody to work on Saturdays, hey, we're going to finish this important task, the person will leap at the opportunity to be of service and so on. So this is the impression of the worker if you ask any boss today. Rarely, in fact, I challenge you to find a boss who would say that the ideal employee is one who is thinking about talking to other employees, forming a union, collectively coming to me with proposals for reform, and regularly meets me and asks for more money. You're not going to find that, right? And this is the impression or the ideal employee image that was prevalent throughout the century. If you take back even before modern work arrangements, the quality of an employee was loyalty. Okay? You need loyal employees, people who would continue to work without your active monitoring. And that was the ideal employee, people who always had your best interests at heart. Okay? So that was the situation. And it was not easy for workers to organize because there were a number of laws or traditions that worked against collective representation. So for example, as early as 1805, workers who collectively met were charged with conspiracy, criminal conspiracy. So to form any kind of union would have been a criminal conspiracy. Right? So that was in place till 1842, when the courts declared that it is not illegal to form a union. So in other words, forming a labor union by itself was not an illegal act. Okay? So people were working 13 and a half, 14-hour work days, and conditions were bad. They were often in poorly ventilated areas, overcrowded, dangerous kinds of conditions. So this continued for a while. During the Civil War, labor unions grew and strengthened, and there were about 270 unions with about 200,000 workers. And in 1868, the federal government made the 8-hour workday the standard workday for its employees. So at that time, there were two unions. One was the Knights of Labor, and the other one was the American Federation of Labor, known as the AFL. So there was always labor strife going on. How are we doing? So there's always labor strife going on, and people were going on strike. And one instance was in the Pullman factory, right? So the Pullman Palace Car factory. And what the Pullman company did at that time was thought to be very progressive was it provided housing for the employees in a designated, I would say a gated community type setting. But the workers had to pay rent and utilities and everything. But when there was an economic downturn, wages were cut, but the rent stayed the same. So in other words, the workers had to still pay the same rent, but their pay was cut. And this led to workers going to management and asking them for increased pay, and 3 of them were fired. It so happened that these fired employees were part of the American Railway Union, and so they tried to protest by saying that to the customers, they tried to do a customer boycott, like what we would call today a customer boycott. They told the customers, hey, don't attach any Pullman cars to your operations. But they had opposition for sure. The contractors, they were part of the General Managers Association, and the General Managers Association came up with a brilliant plan of attaching U.S. postal cars to the trains. So So now when you are striking, you are going against the U.S. Postal Service, which was a criminal activity. You couldn't do that. So they broke the strike that way. And there were also other ways in which the employers would strike, or strike back rather. So for example, they would have yellow dog contracts. And these were contracts where you had to agree not to join a union. And to read you one description, the editor of the United Mine Workers Journal said, "This agreement has been well named. It is yellow dog for sure. It reduces to the level of a yellow dog any man that signs it, for he signs away every right he possesses under the Constitution and laws of the land and makes himself the truckling, helpless slave of the employer." Right. So yellow dog contracts were enforced. Another weapon that employers used was injunctions, so they could get the court to decree that striking is illegal in one of the contexts. So for example, the Red Jacket injunction in 1927 barred United Mine Workers from organizing anywhere in West Virginia. So it was a blanket injunction against organizing. So the other major thing that happened was, we need to remember that the act was passed during in the aftermath, or rather during the Depression. So the Great Depression started in 1929 with the stock market crash. 15% of the world GDP was wiped out. If you want to compare that with 2008, 2009, only 1% of the world GDP was wiped out. So it was a big deal. And thereafter, in the 30s, there was a major drought. Crops were failing. Prices, there was actual deflation going on. So it is in this context that this act becomes significant. Right? And who was responsible for this act mainly? And this was Senator Robert Wagner. And he had, as I was reading through this, it seemed to me that his own personal story had an important effect on his passion for this legislation. So he was born in Prussia, now Germany, immigrated to the U.S. with his family. His dad was a janitor in New York. But he managed to, he went to public school, but he managed to go to law school, and thereafter launched his political career. Now, in 1911, there was a fire in the Triangle shirtwaist factory. And some of you might know that. So what happened was, this is a tall building in the Greenwich Village near Manhattan. Factory was in the 8th, 9th, and 10th floors of the building. The owners had locked the stairwells and the exits so that people couldn't take unauthorized breaks. And when the fire started, people couldn't escape, and they started jumping out from the windows to escape the fire. So this was a terrible tragedy. About 123 women died, 23 men died, and an inquiry was launched into this fire. And Robert Wagner was in charge of that inquiry. And it seems to me that really affected him. What came out of the inquiry was a number of labor legislations came out of that act in New York State. And also the workers formed the Women's Government Workers Union. So I think the fire was an important part in that. So as a precursor to the NLRA, there was the National Industrial Recovery Act. And this allowed for, and the background, I should mention the background for this. So people were depressed, the economy was depressed, banks were not allowing people to withdraw money and so on. And people were tired of the strife between labor and the management. So what they did was, there was a mood in the country for cooperation between labor and management. So they came together initially at least, and said, hey, we're going to work together for the good of the country. And they came up with the National Industrial Recovery Act, which allowed for employers to get together and come up with a common price for an industry. So there was price fixing in that sense, and there was minimum wage laws, so it was supposed to be a win-win for everybody. And then, so everybody was happy with this. People were singing praises of it. There was a ticker tape parade in New York celebrating it, and so on and so forth. Unfortunately, the act was overturned as unconstitutional. So at this point, so that increases the significance of the National Labor Relations Act, because it enshrined these protections. The right to organize collectively and be represented was enshrined into law in 1935. There were significant challenges to the act after that, particularly a case with a steel company, which was ultimately also ruled in favor of the administration. And by the way, FDR at the time was accused of trying to twist the arm of the courts as well. He wanted to expand the number of judges so that he could have more judges who would be in favor of the act and so on. But ultimately it passed, and as a result, a lot of people, more and more employees started asking for unions and so on. What is the aftermath of all this? Well, in 2 more minutes. So this was landmark legislation in the sense that it, as I said, it made it official that the federal government has the back of employees, so to speak. But it didn't really talk about the responsibilities of the employees themselves. So there were a lot of instances of union excesses and abuse and so on. And since that time, progressively, the pendulum has swung the other way. Right? In terms of industrial work stoppages, there were more than 1,000 in 1947. And in 2009, there were only 5. Think about it. Only 5 stoppages compared to the thousands in 1947. Union membership has gone down. Right now, we have a total of about 10% of workers who are unionized, 35% are in public sector, and only less than 7% in private sector. So is this a failure? I would say not. I think it speaks to the success of the NLRA that fewer and fewer people feel the need to be collectively represented, because the non-union workforce also has to be aware that if they don't protect the workers or treat them fairly, there's a danger of unionization. So in conclusion, I would say that the National Labor Relations Act was a significant watershed moment in the history of labor legislation in the United States, and it effected significant societal change, because the worker of today is much, much better off than the worker 100 years